Welcome to our case study on the consequences of failing to disclose assets in bankruptcy filings. This video is a work of fiction, but it incorporates real events and experiences encountered by Praetorian consultants. It's a tale about John Doe, a man who thought he could outsmart the system, and spoiler alert, it did not go well for him. Over the next few minutes, we'll dissect the catastrophic fallout of John's ill-advised choices, and more importantly, we'll learn how to avoid ending up in a similar predicament. So John, thinking he's pulled the wool over everyone's eyes, eagerly awaits his fresh start. But reality, as it often does, had other plans. The court, wise to his little game of hide-and-seek with his assets, decided to deny his bankruptcy discharge. John's grand plan had backfired spectacularly, leaving him in a worse position than when he started. But wait, there's more. As if the denial of discharge wasn't bad enough, the court decided to add insult to injury. Bankruptcy courts don't take too kindly to being lied to, so what did they do? They dismissed John's entire bankruptcy case. All the protections John had hoped to gain from the filing, the automatic stay on creditor actions, the structured repayment plan, evaporated into thin air. Now you might be thinking, okay, that's rough, but surely it can't get any worse for John, right? Oh, my sweet summer child, you underestimate the depths of despair John was about to plunge into. Hiding assets in a bankruptcy filing isn't just a bad idea, it's illegal. John was facing the full force of the law, and it was coming at him faster than a cheetah on a sugar rush. The charges were read, the trial commenced, and the evidence, well, it wasn't exactly on John's side. Remember that idyllic vacation home John was trying to shield from his creditors? The one with the infinity pool overlooking the Bahamas? Yeah, that's gone now.
The bankruptcy trustee seized it faster than a seagull on a hot dog. The assets were liquidated, sold off to the highest bidder.
Now let's pause for a moment and delve into the hypothetical. Let's imagine, just for kicks and giggles, that John had somehow managed to slip through the cracks and receive his discharge. Because here's the thing about bankruptcy courts. They might be slow, but they're thorough. His discharge revoked, his debts reinstated. Remember that whole fresh start thing that bankruptcy is supposed to offer? Yeah, that ship had sailed for John and it wasn't coming back. His little escapade with financial deception had earned him a one-way ticket to bankruptcy ineligibility island. For the next 8 years, John was barred from even thinking about filing for bankruptcy again. And the worst part? He'd brought it all upon himself.
But wait, there's more. John was hit with civil penalties that would make even the most hardened pirate captain weep.
Remember those creditors he thought he could outsmart? They were back, and they were not happy. They hired a legal team that could rival the cast of Suits, and slapped John with a judgment that would make his bank account cry. He was ordered to pay $10,000 in damages. Let's talk about John's credit report. That digital record of his financial history follows him like a shadow. Bankruptcy leaves a mark on your credit report. But add a fraud conviction, John's credit score plummeted faster than a skydiver.
You'd think the bankruptcy trustee would have moved on, satisfied with exposing John's deception and seizing his assets. But no, this trustee was like a dog with a bone, determined to get to the bottom of John's financial shenanigans.
They dug deeper, scrutinizing financial records with the tenacity of a detective in a film noir. John's web of lies was unraveling fast, and he was running out of places to hide. John Doe's attempt to deceive the bankruptcy court led to devastating consequences. His dream of a fresh start morphed into a nightmare of legal battles, financial ruin, and a reputation tarnished beyond repair. This case highlights the importance of full transparency and honesty when filing for bankruptcy. Remember, honesty is the only path to a fair resolution. Attempting to game the system will only lead to further financial distress and legal ramifications that can haunt you for years to come.